This webinar is provided by SC Appleseed Legal Justice Center to provide information regarding the return of SNAP time limits for able-bodied adults without dependents, also known as ABAWDs. The information will be presented by Sue Berkowitz, who is the director of SC Appleseed.
What is South Carolina Appleseed? Most of you who are on here have worked with us in one way or another. South Carolina Appleseed, we're a public interest law firm, and we fight for low-income South Carolinians to overcome social, economic, and legal injustice. And unlike those of our friends who are on here from Legal Aid, they're the very important law firm that does the one-on-one legal assistance. Our office works on policy, training, advocacy, working up at the State House and with state agencies. So we're glad we're able to partner with all of you to be able to work for this particular population. Today, what we will cover in this presentation is what is the SNAP time limit. And for those of you who are as old as me, you might want to be reminded that SNAP is the new name for what we all remember as food stamps. What and why are we facing this issue now? The South Carolina SNAP program timelines. Who will be affected? Any exceptions? For example, who is exempt from the time limit? How ABAWDs can continue to receive SNAP past the 3 months under the timeline limit rule, qualifying work hours for individual exemptions, and most importantly, and why I hope you're on this, is how community-based and faith organizations can assist the client population who may be impacted by this new rule. So first, let's talk about who must meet the time limit. The federal regulations refer to this group as able-bodied adults without dependents. And, you know, in the work that we all do, we have an acronym for everything. And this acronym is ABAWD. All ABAWDs are between the ages of 18 and 49 years old. They're childless. That means they have no dependent children under 18 in the household. They're unemployed or underemployed, less than 20 hours a week in job or job training or a qualifying activity, and non-disabled, meaning no documented disability that would preclude them from employment. The SNAP time limit, well, SNAP benefits are limited to the 3 full months in any 3-year period, unless you can show the individual lives in a waived area of the state. And as of right now, South Carolina has no waived areas. And I'll explain a little bit what that means in a few minutes. That person is working 20 hours a week, is in a qualifying job slot 20 hours a week, or participating in community service work, or meets one of the very few exceptions. States do not have to offer job or training opportunity. Now, South Carolina does have an ENT, voluntary ENT program that's right now run by the South Carolina Department of Social Services. Now, DSS did try to get approval from the Food and Nutrition Service to move that all over to the South Carolina Department of Employment and Workforce. The Food and Nutrition Service refused to allow that, but it does turn out that DSS may be able to enter into MOUs, Memorandum of Understanding, with SCDO, and we still don't have, and I wish I could tell you we did, but we still don't have the finalization of what that's going to look like or if it's actually going to happen. I know that there is some concern up at the State House about that, and there may be some efforts to limit that. Because as we all know, SCDO is not in all of our counties. In fact, SCDO is not in most of our rural counties, so it can make it very difficult for those of us who work in rural counties and are working with this particular population. So where did we get all this? What's the history on all of this, and what's the context of it? While we talk about it as a new rule, because we haven't seen it in South Carolina in so long, believe it or not, this is a 20-year-old rule that came out of welfare reform, for those of you who remember the last time we did major welfare reform was in 1996. And and while welfare reform was mostly dealing with the aid for family with dependent children, now the family independence or TANF population, there was an imposed time limit on the eligibility of certain SNAP applicants, even when they were complying with all of the other program requirements. And that came out of some of the misconceptions that people just go on SNAP because they don't want to do anything else, and they're just going on SNAP so they get a little bit of food, but then they don't do anything else with their lives. Well, as were a lot of the other myths that came about in welfare reform. Well, the USDA waives the time limit for states who have high unemployment or high labor surplus. And the bad news and the good news is, the bad news is we're a poor state with high unemployment, but because the good news is because South Carolina has historically had higher unemployment than the rest of the country, the majority of our counties or MSAs, which are metropolitan statistical areas, actually had a waiver for over a decade. And then during the ARA, the American Recovery and Reconstruction Act, when our whole country tanked in 2008 because of some pretty poor policies that allowed Wall Street to really put us into a recession, that act actually suspended the time limit provision for all states for 2009 and 2010. Well, South Carolina, because we've had such high unemployment, we've had a full state waiver since, well, like I said, for at least a decade. Now, with the economy improving and unemployment declining, many states will no longer qualify for a statewide waiver, and they have to reinstate the SNAP time limit. I will tell you that South Carolina still qualified for a waiver in 2016. And the reason we qualified for a waiver in 2016 is because we have such high unemployment, meaning we're higher than the rest of the country, that we were allowed to initiate a full state waiver. We were allowed to initiate this full state waiver because South Carolina actually could have had extended UI benefits, but our state, in its infinite wisdom, decided not to do the extended UI benefits, but also had decided that they were not going to allow our state to have a full state waiver for the ABAWDs as well in 2016. And a lot of this has happened because there's been a big push among conservative political groups to do this. Groups like ALEC and NGA, which have been doing everything they can to limit programs that help people who are in desperate need, like SNAP and TANF, and have a lot of model state legislation that they've been pushing. So South Carolina, unfortunately, fell into that category of wanting to get rid of the waiver, and did so. I will say that South Carolina's waiver does not start until July 1st. Most states that have given up their state waiver started January 1st. The good news, bad news is that the bad news first, we had a terrible flood, as we all remember, in October, which required us to apply, meaning our state, apply for disaster SNAP benefits, which took the state a month, but they did apply for disaster SNAP benefits. And because they were dealing with all of that, they decided to get a 3-month waiver. So we are starting 3 months later than most states of getting rid of their entire state waiver. So we are going to have the benefit of learning what's going on in other states, as well as having a little bit more time to actually prepare ourselves meaning the social service provider community, the legal community, to help protect those who would be impacted by all of this. So some of the key messages about this 3-month time limit is, it is a time limit. When you hear people talk about it, meaning policymakers, when you hear about it in a political context, it's talked about as a work requirement, but it is not a work requirement. It is a flat out time limit. We are cutting SNAP benefits to this extremely poor and vulnerable group, which will cause widespread harm. And identifying existing ABAWDs requires an individualized assessment of their circumstances, and that should be done for every single person who's being notified that they may be cut off. And it's going to be up to us, meaning the social service provider and the legal community, to make sure that we get the word out to folks, we help them understand this, and we help people who are truly not ABAWDs and shouldn't be cut off, not cut off, and those who may be facing this time limit, how they can participate in programs and try to avoid losing their benefit. So, what is the timeline in South Carolina? In the winter of this year, DSS did an assessment of individual circumstances, meaning they did a review of their caseload. And they sent a notice to potential ABAWDs in March of 2016. And some of you actually may be on this webinar because you got a call or you had somebody come into your office with a letter and they don't understand what it means. The time limits themselves were reinstated on April 1st, 2016. Notices were going out with a checklist for exemptions and should have gone out to everybody in April of 2016. And some ABAWDs will exhaust their 3-month eligibility and lose their benefits on July 1st, 2016. And the reason we're doing all this ahead of time is we hope by having these conversations with you, whether they're coming into your food pantry or coming into your office or making phone calls to your intake lines and saying, I got this letter, I don't understand what it means, you can set up appointments or you can talk with them and you can help them with either deciding whether or not they should apply for an exemption, they fit into exemption, or whether they may not even truly be an ABAWD. For an example, if a woman is pregnant, even though she's a single woman with no children in her household when she applied, if she's now pregnant, she would be exempt. And or if somebody when they applied as a single household member, but there are dependent children in the household, and that what they might want to do is come together as a whole household and family so they can get their benefits together. Those would be not just exemptions, but that means they're truly not an ABAWD because they are not without a dependent. And when we think about who are affected by the SNAP time limits, it really is people who are struggling to put food on the table, probably people who are lacking insurance, have huge housing instability, and already have trouble paying their bills. So as usual, we're going after the most vulnerable people in our state. So once again, we want to mention who must meet the time limit. If it's a low-income person without children in the household who works less than 20 hours per week, they're between 18 and 49, childless, meaning no dependent child under 18 in the household, unemployed, underemployed, less than 20 hours a week, or in job training or a job component, and non-disabled, no documented disability that would preclude their employment, then those individuals will be considered an ABAWD. When we think about who these individuals are, they're the poorest of the poor, because unfortunately, most terrible rules like this are often put into place because they're going to impact the poorest of the poor. 4 out of 5 have income below 50% of poverty. That means people from 0 to 50% of poverty. And for one person, we're talking about under $6,500 a year. 82% of that population are who are ABAWDs. 51 those who are 51% of poverty to 130% of poverty, because I'm sure you all remember that the cutoff for SNAP program is 130% of poverty. 18% are in that income range. So we really are talking about our most vulnerable adults. Almost 1/3 are over the age of 40. And so that means 32% are between 40 and 49, and 22% are between the ages of 30 and 39. Really, less than half of the individuals are in that 18 to 29-year-old age range. So we're also talking about folks who have probably been historically poor and vulnerable, and that's who we're going after. Everybody probably, when they think about ABAWDs, think it's always men, but actually 40% are women. So what we're talking about are folks that probably have found themselves in real dire circumstances for a very long time. For example, a lot of these folks are probably veterans. We know we have an incredibly difficult problem with homelessness among veterans. A lot of because of the circumstances they lived under when they were in the military and they came back dealing with PTSD and possibly having some substance abuse problems, many of them who are living on the street. And so we know that a high population, and nationally it's probably at least 30% are veterans, and that's probably as true here in South Carolina. It could even be higher because we do have a high homeless veteran population. So we know who our ABAWDs are, and we know who our ABAWDs are not. Let's talk about exceptions. Who's exempt? So you might be between 18 and 49. You might not have a dependent child in your household, but you may still be exempt from the SNAP time limit. And that's where the analysis, that's where we can all be of help when people come to us. So who does not fall under that time limit rule? If an individual meets the following exceptions, they can continue to get SNAP, and they wouldn't even fall under the 3-month rule. So they live in a waived area in South Carolina. Now, unfortunately, there isn't any that have been currently waived. I'm not going to tell you that there are not areas in South Carolina that could be waived because they have 20% or higher unemployment. In fact, we did an analysis not too long ago for some members of the South Carolina Senate, and I believe we found over 20 counties that would fit in. And then if you group them the right way, there could be maybe 24 counties. But at this point, the state has decided that they're not going to apply for an exemption for those counties, but we're going to still work on that. Once again, remember, if you're under 18 or over 50, and I've been getting emails from people who are worried, and from somebody who's 60 years old, and I would say, well, I'm sorry, but you're not even an ABAWD. We can't even call you that. Remember, that is, you have to remember that most of all. If somebody is pregnant, if a woman is pregnant, she doesn't fall under the rules. She's just not an ABAWD. If you're exempt from general SNAP work requirements, you would not be considered an ABAWD. If you're responsible for a dependent child or residing in a household, same SNAP case, where a household member is under 18, and the other piece that I think is very important, or an adult that needs caretaking, or you can show that you are the primary caretaker for an adult or a vulnerable adult, and you can document that and you let DSS know, then you would be exempt. You would not fall under the rule. So let's go through that again. If you have someone in the house that you're taking care of, or you can show that you're responsible. You may not live with that vulnerable adult, but you can show that you're a caretaker for that adult. You're having to spend time with that adult, and you can show documentation from a doctor that that person needs that caretaking, then you could find a way to make that person exempt. If you can show somebody is physically or mentally unfit for work, and we've had this discussion before with other groups. When I say physically or mentally unfit, doesn't mean that you've necessarily receiving disability. If you're receiving disability, that's a no-brainer. You just show you're getting SSI or Social Security disability, or maybe you have the person has a private disability policy and they're getting disability. That would take you out from under the rule. But if you can get a doctor or a mental health worker or a social worker to write a note showing that this person, especially for mental unfitness, that this person cannot go to work because of mental unfitness, then you would be able to show that individual is exempt. And I also want to mention for purposes of VA, there was a letter that was just issued by FNS to say somebody would not be considered an ABAWD if they have any percentage of disability under VA. Now, for those of you who do VA work, you know that you can be 100% disabled, or you can be granted another form of disability, meaning you're 10%, 20%. If you have been assessed any percentage of disability for purposes of VA, then you would be considered disabled for purposes of ABAWD. You need to take that letter to DSS, you need to show that to them, and then you would not fall under the rule. You're just not an ABAWD. The other group are the chronically homeless. And so if you can show that you've been chronically homeless, that you're living in a homeless shelter, you're living on the street, and that's been for a period of time, or that you're now in a homeless shelter and you don't have a likelihood of finding a home, then once again, it's not that you're an exempted person, you just don't fall under the time limit rule. Those are folks that are not considered ABAWDs. So let's go back to identifying those who are physically or mentally unfit for work, because I think for excuse me, those of us who work at legal services or work for other social service providers, we probably know who those folks are. We see them. So you're not subject to the 3-month rule time limit if you can determine that you're unfit for work. And there's 3 ways that you can do that. We talked about that. You're receiving temporary or permanent disability benefits issued by government or private source. So private source could mean private disability insurance, obviously government, SSI, or SSA. And I would also argue that if you're getting workers' comp benefits right now and your benefit isn't high enough that you would be still eligible for SNAP, that would work as well. Obviously, or mentally, physically unfit as determined by the SNAP worker. That means when the person goes in, if the SNAP worker in meeting with them through an assessment, and that could be just by a conversation. I think we've all been put in that position where we understand that it may be true that somebody is struggling with getting benefits, but that doesn't mean that individual, meaning benefits, SSI or Social Security, but that doesn't mean that that person is not in a position where that they could be determined that by the SNAP worker. And of course, anytime you have a statement from a physician, a physician's assistant, a nurse practitioner, a representative of the physician's office, a psychologist, and a social worker. And we did this presentation for some social workers at the library. And I do think that, if you are someone who's working with an individual who's been traumatized or has what you consider mental health issues and concerns, and you're a licensed social worker, there's no reason why you can't provide a letter that you're working with someone that you think that at this point they're not able to, to work, that you're working with them because of a mental impairment, and any other medical personnel determined appropriate by the state. And that information can be sent to given to the DSS SNAP worker, and that should help the individual who would be identified as no longer being an ABAWD. Therefore, the time limit does not apply. What if you're working with someone who did not get to you until August 1st because they really didn't understand or pay attention to the information and the letters that they received, and the clock started ticking, and they never did anything to get DSS to find them as not being an ABOD, and somebody doesn't have to be under the 3-month rule. They could tell the DSS ABOD worker, and my understanding has been that there'll be somebody at DSS in the different county offices that will be available to take this information. But I think in general, you would take this to the DSS office and get that to the SNAP program immediately. So someone who should have been identified under the rule can get identified and reclassified. In addition, the state office will be willing to help with that. And Amber Gillum, who is the deputy director at South Carolina Department of Social Services, is willing to receive information from social service providers and individuals who work with the SNAP beneficiaries. She's not going to be able to work with each individual SNAP beneficiary, but we will, when we get the materials out to you and send them out, we'll get you her email as well and make sure that you have her information. So if you think you've contacted your DSS local office and they're not doing what they should do, she will have the opportunity to reassess this. I'm not sure she realizes, how much work we're all going to do to make sure people self-identify, and at that point there may be another process that comes about where DSS will make sure their workers truly understand this. But it's always important to let your county office know, get that information in. And I'll also mention, when you take information, whether you take it in for the individual or you get the information put together and have the individual go in, make sure when that information is sent to DSS that you have 2 copies, so that one copy can be clocked and stamped, and you can always prove that DSS got that information, because we all know it's a big agency and things have gotten lost before, and you want to be able to prove you let DSS know. So continuing to receive SNAP after the 3 months, what if you've done everything you can to assess whether or not that person truly is an ABOD? You've determined that person is not an ABOD, but you want to help them stay on the program. Well, there's 2 other ways we can make this happen: qualifying work activities or an individual exemption. DSS does have the opportunity to ask to allow for 15% exemption of people, and meaning 15% of all ABODs can be exempt for a period of time, and that's not for the whole year, that's 15%. And through the calculations, it's each, after you use up 3 months, that goes towards the 15%, but they have the opportunity to do it. And I think probably what they will do is use some of those individual exemptions. If they find people who become qualified through qualified work activities, they may use some of those exemptions to keep the benefits going until the person's fully in the qualifying work activities. But if this sounds confusing to you, it is confusing, and it's going to be a mess for a while DSS puts all of this back together after not doing it for over 10 years. So I think for most of us, what we're going to have to focus on is helping the beneficiary who is absolutely an ABOD, is not going to qualify for any exemption, how we help them get into a qualifying work activity. So ABODs engaged in a qualifying work activity can continue to receive beyond the 3 months if they are: 1, working 20 or more hours a week, averaged monthly. So that means 80 hours a month. So if you've got someone who's working 80 hours a month and they do it through 30 hours one week, 10 hours one week, 20, and you can show that's 80, that's 80, then you can show they worked that average 20 hours, they would still be eligible. Participating in a qualifying work training program approved by the SNAP office, 20 hours or more a week, averaged monthly. And that's going to be through their voluntary ENT program. that they're going to be doing either through their own programs, and there's 17 E&T workers right now at DSS who may or may not be transferred over to do. They will be the ones who can help them get into that qualifying work and training program. Participating in a program under the Workforce Investment Opportunity Act, WIA, which may include job search, job readiness, occupational skills training, education, and activities of 20 hours or more a week, averaged monthly, and that would be through due. A combination of working and participating in qualifying work program 20 hours a week or more, or complying with a work experience assignment if one is made available. So as nonprofits, we all need to kind of quiver in our boots about this, because a qualifying work experience assignment is basically volunteering at nonprofits. And I always talk about, well, we know how easy it is for us to have volunteers at our offices and trying to oversee them and monitor them, because we all have our own volunteer coordinator, right? I mean, don't we? Because we're all so big and we have that going on. So that's going to be a little bit more difficult, and especially in counties like Allendale or Bamberg or Lee, where you don't even have that many nonprofits. How we're going to have having those kinds of work activities is going to be very interesting for us to be able to figure out. It also means maybe going to the housing authority and seeing if they have work activities, or going to your municipal government and seeing if they have work experience activities. And as soon as we have information exactly what's going to be going on with the employment and training offices, exactly where they're going to be located, and exactly where all those work folk for those programs are going to be, we will share that. The other thing that I do want to mention is with all of this is, for an activity to qualify, the one thing that will not qualify as a work activity is a job search. So you can spend 20 hours a week, you can spend 100 hours a week looking for work. That in itself will never be a qualifying work activity. Individual exemptions. We talked about exempt roughly 15% of its caseload that is subject to the time limit. USDA will provide a yearly accounting with new and unused exemptions. So that means, for example, if this year DSS has 15% exemptions, doesn't use any of them, that means in the next year we'll have 30. But we haven't gotten a definitive number yet from DSS, and hopefully we'll have that and we'll know how it's going to be used sometime in the near future. It allows the state to extend SNAP eligibility to individuals who would otherwise be ineligible because they exhausted their 3 months of eligibility. Now, DSS may try to find ways in some of the more rural counties to use it. We're just not sure at this point. And each individual exemption is only for 1 month for each person. So 15% among the 60,000 people who got notices, and probably the 30,000 who are truly ABAWDs, is not going to go too far. The state can also ask for a waiver for our high unemployment and high labor surplus. As I told you, we really do have counties that would absolutely qualify for that. In fact, our whole state would actually qualify for an exemption. We have not been able to make that happen yet, but you know us here at South Carolina Appleseed, if there's a will, there's a way. We'll keep trying. And we don't know yet what our state's personal exemptions are. We are worried that because of the way we were able to exempt for all those years, we may not have as many left over. Some states never use them, and they're in much better shape. Okay, this is why we wanted everybody to be on this webinar today. How can you help? Well, first of all, the most important thing we can do is educate our clients and the communities we serve about the time limit rule and its impact. And that also means standing up for why this may not be such a great idea in both public meetings, talking to policymakers, letting community leaders understand about it. And I do think there's a lot of folks out there who understand it's not necessarily in the best interest of the population that's being impacted. And this isn't about work, it's about time limits. But until we can turn this around, and you know me, I'm always, for those of you who know me, I'm always hopeful. We need to work with clients impacted by the time limits by doing the following. One, first of all, let's figure out if they need an exemption. Obtain documentation. Explain the ways they may be considered unfit for work. Help them obtain those documents for unfitness. If you think the person's not even an ABAWD because they live in a household where there's a dependent child or where there's a dependent adult or the individual's helping somebody who is a dependent adult, help them get that documentation, let DSS know, and help that person get accepted from all of this and keep them on benefits. And that means really mediating with the SNAP office on behalf of your clients that have been wrongly classified as an ABAWD, or helping DSS understand that your beneficiary, your client, meets or could meet the exception, or help them meet or qualify for a work activity. And that may mean seeing if your organization can help with work experience. It may mean helping them get into a WIA program. It may mean getting them into the voluntary ENT program. Now, I know for those of you who are in rural counties, you're going, well, I can't help someone because I don't even have a due office in my county. How am I going to get that person to any kind of work activity program because they don't have transportation? Well, because we have a voluntary ENT program, there is some money to help with transportation. ABAWDs will be given a priority for all the ENT slots, and they will get some benefit, get some resources. Now, it is only $50 a month. And I know those of you who may be in a rural county right now are hitting your forehead going, well, $50 may help for the first week, but I can't get somebody to where they need to be from my county with only $50 a week. I was doing this presentation down in Charleston, and somebody told me just to get from Edisto Island to Charleston can cost somebody $30 a day. So I realize that that is not going to be incredibly helpful. Unfortunately, lack of transportation is not going to be a qualifying way to keep someone from being considered an ABAWD. You might be able to get them the 15% exemption, get them into the 15% exemption, but it's not, those aren't going to last for very long. But it's going to be up to us to help. So as people are calling you and saying, I got this letter that I might be cut off of SNAP, ask them if you can see the letter. Make an appointment, get them in, look at the letter. If you go through the checklist with them and the checklist is confusing and we have not been able to get a simplified checklist done for DSS yet that they will approve, help them with the checklist. If you think that they are they meet one of those exemptions, check it off, make a copy, get it sent in, make sure you can prove it was sent in to them, get it to the DSS worker, or contact the central office. We'll get you Amber's email and get them exempted. If you can't get them exempted, then the next step will be help them get into a qualifying work activity. But understand that looking for a job is not going to be enough. It's going to have to be a qualifying work activity that DSS will approve. And even if it's not something they have, you can get them the information. For example, if you want them to volunteer at your program and you're willing to supervise them, get them a letter to volunteer. Or if you can work with your city that they've got some jobs that can help people they're not paying jobs, and they're not going to be displacing a paid worker for doing that work, then maybe you can get them to write a letter and you can help them by getting it to them. But it's going to be up to all of us. One, we've still got about 6 more weeks to identify, find people, help them become accepted if they're already accepted. But more importantly, for those who we know are truly ABAWDs, what we can do is work with them to help them show that they're in a qualifying activity so that their benefits don't get cut. So now is the time. If anybody has any questions, Brandon's here to help me understand if you put a question in. And we don't have any questions right now. So I would love to believe that's because I do such a good job explaining what I think is an incredibly confusing program that nobody has any questions. We know you're still on. We haven't seen everybody log off, but we will send you the information. We have an email we're going to put together to send out. Oh, I take that back. Can I explain the 3-month rule? Yeah, that's a fundamental issue. The 3-month rule is if you are an ABAWD, meaning if you're an able-bodied adult without dependents, and you're receiving SNAP, you can only get SNAP for 3 months. It's a time limit. You can only get SNAP for 3 months unless you are in a you can show you are truly not an ABAWD, or you go into a qualifying work activity. If you go into a qualifying work activity, your benefits continue. If you don't, your benefits end. Okay. Next question. Right now, there's no telling which DSS office is handling the case. Will it be the local office for these notices? My understanding is, now you can always call the DSS question line, but I would take those notices in to your local office, because that's the best way for you to be able to show and document that you've sent in that information for your particular client. I'm always nervous about mailing things in to a central area. Who is exempt from SNAP work requirements? One of the exemptions. You're only exempt from the SNAP. Okay, let's remember, this is a time limit. If you are not exempt, you are in the time limit. If you are an exemption and an exception, you don't have to follow the time limit. If you are assigned one of the 15% exemptions, you are exempt from the time limit. Or if we are able to have counties or MSAs that are exempt, then you will be exempt. Otherwise, you are not going to be exempt from the work requirement. If you are an ABAWD and you have a dependent child, you can show you have some form of disability that you can document even though you have not been found disabled, or you have somebody who you're a caretaker for in your household, then Mary Lou, you will not be you can show that you are exempt from it, but then you really will fall into one of those exceptions. If I get a job, I have to reapply if it's after the 3-month rule. If you get the notice and you're cut off and you ask for a fair hearing within the fair hearing amount, and you can show, wait a minute, I have a job, I would argue you could do it through the 3-month, you could do it through a fair hearing if you think that you can get that done quicker. If not, you can always reapply and show that you are no longer an ABAWD because you're in a qualified work activity, and therefore you should be able to get benefits. But you can always within that time frame show them that you've you're now in a qualifying work activity and do it that way. There was a slide that had a list of ABAWD exemptions. There's one. Oh, I'm sorry, Mary Lou. You're right. I forgot. If you are pregnant, you are not an ABAWD. If you are pregnant, you're exempt. You're exempt from being an ABAWD completely. You are no longer considered an ABAWD because even though being pregnant is not a disability, you technically have a dependent that you are responsible for, and you're allowed to get SNAP benefits, and you're not under that 3-month rule. Sorry about that. Does that help? Oh, okay. Mary Lou sent us a smile, so that does help. Thank you for reminding me, Mary Lou. I appreciate that. Do we have any other comments or questions? We're looking. What is the average amount of the benefit that these folks are receiving? Volunteer hours are valued at about $10 per hour. Is there a work rule contributing the $800 of work? Well, they're not going to look at $10 an hour, Dean, because unfortunately we haven't gotten to $10 an hour for our for FLISA purposes. It's still $7.25 an hour because South Carolina doesn't have unfortunately, a minimum wage. So they would look at minimum wage, but with the 80 hours a month, people are still going to be eligible. And I apologize. I believe the average benefit for somebody who is an individual is about, last time I looked, was about $130 a month for a South Carolina individual. I hope that answers your question. And we do need to fight for increasing the minimum wage, although I like to say we should just need to fight for a fair wage, a living wage. But it would be wonderful if we were someday up to 15 an hour, because you're right, that would probably take everybody out of the 20-hour. That 20-hour rule would be a lot harder for them to justify under labor laws. Okay. Any more? Okay, we don't have any more questions. We're done a little bit early. We're going to send the slides out to you. My slides have my email. Always feel free to contact me as for you guys. I do want to say we are not able to help every individual who is impacted. What we're trying to do is help all of you who are helping impacted individuals. So if you have a question and you're not sure, email me. If I'm not sure, I can get to DSS. They don't want to get inundated with all of this. I do think that the decision that was made to not exempt all of our counties was not made at a DSS level. That's just my gut feeling. No one will come right out and say that. I think if they had their way, it would be a lot easier just to have kept all of our counties exempt. But this is the rule that we have. This is the rule that we're living under. If anything does change where suddenly we're going to be putting in waivers for particular counties to allow for our high unemployment counties to be exempt, you will not only hear a big screaming and yelling and jumping up and down coming out of 1518 Washington Street, Columbia, but we will get something out to you as soon as possible. So stay tuned. But thank you so much for signing up for this and for caring about this population. This is not always the population that folks worry about. And that's why I'm afraid what may happen to them. So we thank you for the comments that you're sending to us. I hope this will help all of you with screening folks better. But anything we can do to help you with this, please let me know. We're here for that reason. We're all in this together, and we're all in this for our beneficiaries. So have a great weekend, and I'll talk with everybody soon.